Carolyn. Carolyn Brougham, have I pronounced that correctly, Carolyn? Close enough? Okay, good. Is Intellectual Property Counsel, Patents and Technology for Mars Wrigley Company, which is a division, a business unit of Mars Inc. And she provides strategic management of all legal IP related matters, including developing global IP strategies, partnering, managing inventions, managing a huge portfolio, negotiating with third parties, and helping with development and manufacturing, as well as research agreements and material transfer. So, as I promised you, wait, sorry. Let me just move on to her education. She has a law degree from Roger Williams University School of Law in Bristol, Rhode Island, a beautiful location, I must admit. And she has her undergraduate degree in biology from Wittenberg University in Springfield, Ohio. So Carolyn and I met through the Women in Bio group. We are both national leaders of that organization. And Carolyn is the founder of a fantastic program called Boardroom Ready. And what this does is it prepares women, because it's a Women in Bio group, it prepares women to sit on corporate boards. So it's a lengthy, there's a stiff application process. There's a lengthy seminar. I don't know how often they meet, Carolyn. I've not participated in the actual event, but at the end of it, they graduate, and over 100 women who've been through that program are now sitting on corporate boards. So it is a huge win for Women in Bio. Our second speaker, or co-speaker, I think they're going to go back and forth a bit, is Margaux Nair. Have I pronounced that correctly? Close?
It's Nair like fire. I think no part of my name is pronounced like it's spelled.
Okay, all right, very good. Margaux is also IP counsel with Mars Wrigley, but her focus at the company is with plant-related intellectual property of all stages, food production, new plants, growth methods in the field, and incorporation of those plants and plant extracts into food products. So I do not have the pleasure of knowing Margaux in person, but I can't wait to hear her presentation. She went to Chicago Kent College of Law, which is Illinois Institute of Technology in Chicago?
Yes. Yep,
yes, okay. And Tufts University, I know well, is in Boston, Massachusetts, where she got a degree in biology. So with that, I can't wait for you all to see these beautiful slides. I give it over to Carolyn and Margaux.
Thank you so much for that warm introduction. And I assume everyone can see my slides.
Looks good.
Okay, awesome. Well, again, thank you so much for the invitation to speak today. You will not find two more enthusiastic candy eaters in the world than Margaux and myself. We both come from pretty diverse backgrounds, but joined in-house around the same time. And it's just been the time of the trip of a lifetime serving with her. So I'm very excited to talk to you today about candy law, and it's so appropriate being Halloween month. And if you haven't yet purchased your Halloween candy, highly recommend you do that. We just saw some financials in North America business anyway, and it looks like candy sales are way up this year. So we don't want you to get shorted at all for your trick-or-treaters. I'm sure you're used to hearing the standard disclaimer that the materials and discussion provided today are for general information purposes. These are not legal advice, and you should not act or refrain based on any information you received today. Make sure you consult your own legal counsel if you have a specific issue. And also, Margaux and I are speaking on our individual capacity, not those of our employer, Mars Wrigley. So we've got a fun agenda for us today. We'll start off with some introductions, and then we'll do a little bit of candy trivia before diving into the different types of IP. And I'm sure many of you are fairly familiar with, the different types of patents, the hard IP and soft IP, if you will. But we also are going to take a deep dive into plant IP rights, which I really think will be quite fascinating. And then lastly, we'll end with a group case study. So we hope you'll be able to take everything you've learned today and have robust discussion. We'll put you in the role of an in-house attorney and see what you guys can come up with on the spot. So a little bit more about me. I live in Chicago, Illinois. I do have a biology degree, although I don't get to use it much these days. I am a licensed patent attorney for the U.S. Patent and Trademark Office. Prior to working at Mars Wrigley, I was in-house at Northwestern University, where I worked in their office for sponsored research, as well as their new innovations and new ventures office. And I also worked at the internationally recognized law firm of Brinks, Gilson and Leone. I think they've got they used to have an office anyway in RTP. I think that's the only one that's sort of down south. But anyway, it was a pretty large law firm here in the Chicago area. And my favorite candy of all is M&Ms with pretzel. So it's like a salty sweet combination. So if you have not tried the M&M pretzels, highly recommend. And with that, I'm going to allow Margaux to introduce herself.
Yeah, as I'm Margaux Nair. You've heard most of the key parts of my bio. I spent most of the past decade working on agricultural related intellectual property projects at K&L Gates before coming to Mars Wrigley. And part of this presentation will be seeing why you need an ag attorney in a confectionery company. My favorite candy is the Dove Milk Chocolate Promises. I'll just go turn over to the rest of the content.
Sounds great. We're going to start with some trivia. So everyone get your hands on your keyboards. And the first person to put in the chat the response to each of these trivia will unfortunately not win any candy because we can't pass out virtually, but will at least get the pride of knowing they were right at this trivia. So the first question here is, what candy bar was named after a family's horse? And we'll see who can put it in the Charleston Chew. Incorrect. Butterfinger. No, Snickers. Laura, it looks like Laura got that right. So congratulations, Laura. You get the pride of the first question. The next question is going to be, let me see if I can advance here. In M&M's candies, what color did the blue replace in 1995? Oh, Dave Maxwell, I saw the first one is tan. So good job, Dave. I like to see lots of the colors here, but it was tan, it's not brown. So great job. Margaux says it's terrible tragedy. That's too funny. Okay, everyone get their hands ready for the next question. What candy bar originally came in 3 pieces and had 3 different flavors? Oh, nice job, Rich. The 3 Musketeers is the correct answer. But I like seeing all of the different answers to this. So that's great. So yes, it was 3 Musketeers. Next question. Milk chocolate was invented in what country? Oh boy, no, we were still waiting for the right answer. Oh, nice job, Virginia. It was Switzerland. So
hey, honey.
Congratulations.
Honey, Matt?
Oh, and if everyone can go on mute, that would be great if you're not speaking. Thank you. Oompa Loompa Land. Nice job, Bill. You get a bonus point for humor. I'll give you a point for that. All right, next question. What's the best-selling candy in the world right now? There we go. Philip, nice job. It was Snickers. So you can see it was a little bit of a skewed Mars trivia, but nice to see all the answers. And thank you, for participating in the chat. So without further ado, I think that was the last question. So anyway, I know you all are IP experts, and so I won't bore you too much. We won't go into too much detail about the different types of IP protections that you can get. But today we will be covering these top 6 that are on your screen. And something to think about and that I thought would be interesting is, I'm not sure what industries you guys are all supporting and what sort of clients you support, but I certainly came from a very traditional medical device pharmaceutical background, and really we spent a lot of time on utility patents. Of course, we might have had the one token trademark attorney who did, you know, the product names and things, but it really was, everyone was so focused on utility patents. And it wasn't until I joined Mars where I really had to think like not very holistically about the IP strategy, and confectionery and food is certainly an industry in which you can't just rely on utility patents. All of these have a very unique role to play. So today we're going to kind of briefly buzz through the different types of protection that you can get, different types of intellectual property. And I've also included sort of a case study and example for each so that you guys can sort of put your thinking caps on and think about, you know, if you had a similar client, what your strategy would be. So first, we'll start off with design patents. And of course, they're design patents in the US, but in other areas, they're registered designs. For all intents and purposes, they're pretty similar. But you know, with design patents, you're going to be really focused on the unique visual qualities of a manufactured item. It could be a distinct configuration, a distinct surface ornamentation, or both. The USPTO only allows a single claim, and that claim is really the drawings that will determine the infringement. They're very inexpensive to file. They're quick to obtain. 15-year term in the US as opposed to utility patents, which have a little bit longer of a term. Typically takes 19 months to issuance. And the main reason you would file a design patent is to prevent copycat designs. One thing to think about with design patents is that it cannot have function. This is purely ornamentation. And I think back to my law firm days, our firm represented, I think it was Kimberly-Clark, in a toilet paper dispute over the quilted pattern on toilet paper. And let me tell you, the doc review on whether that quilted pattern was functional or design was something else. But you know, do keep in mind that this is really just for the ornamentation, and if it really performs some sort of function, it may actually impede your ability to get a design patent or to enforce one. And so wanted to talk about two sort of case studies here. So the first one is if you have children, or if you yourself were ever a child born after 1979, you likely know what this picture is, and it's a ring pop. So it goes on your finger, and it's got a big hard candy that you can suck on. These were developed in 1979, and there's a number of patents on both the plastic portion as well as the shape and the whole thing together. And it's actually been quite well litigated, which was sort of shocking to me. There were all sorts of issues with it, including a big false marking suit where they continued to mark after the patent had expired. And when you think about how many billions of these are sold globally, the damages amount was, you know, astronomical. So anyway, there's a kind of a fun false marking claim with this patent. There's also some trademark issues that came up on this product, as well as the FTC actually had an action for violating the Children's Online Privacy Protection Act. So I think what happened is the company may have been encouraging kids to take pictures with their ring pop, but some of them could be suggestive, and a bunch of parents filed a class action lawsuit saying that, you know, the children shouldn't have been posting pictures of themselves with this product. It violated all sorts of online standards. And then the last thing is, I guess in the last decade or two, there's been a bit of a dark side with the ring pop in that ecstasy dealers apparently can mix ecstasy into them and make their own ring pops that are used in, I don't know, I leave a pretty suburban, unexciting lifestyle, but apparently there's some drug paraphernalia that can be used with these ring pops. So it's something that they're monitoring. But another example just from Mars that I wanted to put up there, and this is quite interesting, is, you know, this design patent here on the shape of our Galaxy bar, covering that. And we'll talk about it in a little bit, but you can actually have designs as trademarks. And so we'll sort of talk about that in a minute, but just keep in mind, like, you can get design patent protection on a lot of things in the confectionery space. Next up is utility patents, which I'm guessing with this crew is pretty comfortable, pretty familiar with. This should be the stuff you work on as a first-year associate. Protects any new and useful process, machine, manufacture, compositions of matter. These can be a lot more expensive to obtain, but you get more claims. Typically, it's a 20-year term in the US. It typically takes 3+ years of issuance or to get to abandonment. And of course, the concern here is that a competitor may copy how something functions. So I wanted to do a bit of a case study in a utility design patent because I think it's kind of interesting. So if you've ever eaten Oreos in the last decade or more, you know that they come in like a plastic tray with a film on the outside, and it's kind of got this cover that comes off and then it goes back down and it recloses. So that was actually developed by Mondelez, the owners of Oreo, and Sunoco, which is a packaging developer. And it was called like the snack and seal technology to reseal snacks such as cookies. So prior to the snack and seal technology, the way you'd open up an Oreo is you'd open up the side, you'd have to pull out the whole tray, grab a cookie, push it back in, and there was no reclose feature. And so it's really problematic, I'm sure, for parents like me who just want one Oreo at a time. They have to pull it out, it was just inconvenient to get into. So as soon as they launched the special easy access, easy, quick to reseal package, their sales volume increased 4%, which if you think about the billions of packages of Oreos that are sold globally, to have an increase in 4% with very marginal increase in costs for packaging, it was an unbelievably successful package for the Oreo brand. And it's interesting for a number of respects. One of them being that both Mondelez and Sunoco filed patents for it. So Sunoco filed for the base technology patents, and Mondelez filed for the application of how this technology was going to work in a cookie container. And if you're familiar with the drug like Humira that had, more patents than God filed on it, this was the exact same approach that Mondelez and Sunoco took. They filed over 500 patent applications on this technology. In fact, I swear I get an alert once a week that one of these has issued somewhere around the world. It is quite the ring fence strategy that they have both employed on this technology, which of course it's making them a ton of money, so it makes sense there. But it's just absolutely astonishing to think about one package and all the different possible permutations and different ways that they were able to get patent protection on it. And they've really made it very difficult for competitors who are looking to do a reclosable package to kind of get anywhere near this because of the vast array of patents that are on this technology. And I've put in this picture, I don't know if you can really even see it on the right, but I've just showed like one of the base patents, and you can see just every year they are filing just huge amounts of child applications all over the world. And so it gets a little interesting. So Mondelez actually licensed the technology to Chips Ahoy, Reese's chocolate chip cookies, which is a competitor that's held by Hershey. And in 2013, Mondelez filed suit against Kellogg's because Kellogg's launched a very similar package for their Keebler's Sandies products. And it actually went all the way up to the Federal Circuit, where they found the patent was invalid as obvious in view of a standard cookie container, and also if you've seen like resealable wet wipes packages. So it has that same little reclosable feature on top, and cookie containers have this tray in it and the package around it. And the arguments made to the Federal Circuit were like, yeah, but look how much we have sold of this container. Look how much money this has made. This is clearly like a need, a long felt need. And you went through all the secondary factors, but the Federal Circuit said denied and invalidated the patent. But presumably the base patents are still valid and enforceable. Those ones haven't been, those ones have not been challenged. Next up, I kind of want to get into trade secrets. So again, while these aren't really protectable in the same manner as patents or trademarks, it is a really important IP strategy to think about as you're advising your clients. So you probably remember the test, but it's basically anything with economic value that's not generally known to the public and that a company takes or an owner takes reasonable measures to keep secret. There's no filings. It's free to get and it's free to maintain as long as you are maintaining it as a secret and doing all the things to keep it properly considered a trade secret. So there is a lot of industry effort around trade secrets because it has allowed a lot of technologies in the industry to continue to be sold for, decades and decades and decades, and much longer than a traditional patent would have offered that sort of protection. So it's a unique strategy that I think is used much more commonly in the confectionery industry than it has been in the other industries in which I've supported and worked with my clients. But one thing that you have to think about with the trade secret is, what if your competitor comes up with the same technology and then files for a patent on it, right? So you could have freedom to operate issues if you pursue a trade secret, which is why you may consider doing some sort of defensive publication. And so there's all sorts of things to think about if you're going to go ahead with a trade secret management program. And wanted to share with you a little bit of a trade secret case study. So Twinkies, if you're familiar with Twinkies, were invented in Illinois in Schiller Park. It seems like all the great candies of the world come from the Chicagoland area in the 1930s. So the Twinkie, basically they had several machines that were used to make a cream-filled strawberry shortcake. But because strawberry shortcakes were only a summer seasonal food, the machine sat vacant for the rest of the year, and so or idle. So this inventor just conceived of this snack-filled cake with banana cream, which he dubbed the Twinkie, and it's been held as a long protected trade secret of how they make these Twinkies. And this writer, Steve Ettlinger, actually published a book about Twinkie Deconstructed, which was an expose on all of the crazy ingredients that are in the Twinkie, and did all this chemical analysis and wrote this whole book about it. And I'm sure it was unfortunate for Hostess, the makers of Twinkie, because this is one of the best-selling confections in the U.S. It's actually one of the top-selling foods in the U.S. And most Twinkie lovers are probably better off knowing that Twinkies are not made with petroleum and limestone, for example. But among all the stuff that Steve did, he still could not figure out how to reverse engineer all of the Twinkie making process, essentially the cream. So that remains a mystery, at least. But anyway, it was a funny little story about a trade secret, and I'm sure Hostess was not thrilled that this book came out or that all this research went into it. Now, I am admittedly not as strong in my soft IP protection, but I wanted to mention trademarks here. So these obviously are for established goods or a legally recognized mark that identifies manufacturers' unique goods or services. I wanted to mention that there are a bunch of non-traditional trademarks that you can get, including shape, scent, color, sound, motion. So the Hershey Kiss is a good example, where I believe they filed for a design patent on the shape, but then they also kept the shape as one of their trademarks. And there was a bit of a joke in the industry when, I don't know if you remember back in like 2019, bakers were very upset that the tips of the Hershey Kisses were breaking off, and the bakers were very upset that there was like some sort of production issue. And some IP lawyers, of course, had to get involved in saying that, if you have non-use of a mark, it can actually be grounds to dismiss the mark. And so they were saying, well, if the Hershey Kisses don't actually have that pointy shape, that's non-use, and if you don't fix this quickly, we're going to say that you've lost the ability to keep your trademark for the Hershey Kiss. But anyway, that's just a lot of probably IP lawyers with too much time on their hands. Also wanted to mention that Ring Pop lawsuit that I mentioned earlier. The Ring Pop was actually on that trademark, and they were able to protect that long after the design patent expired. These are very inexpensive to get, but they do require continual use in commerce to maintain registration. So wanted to share another trademark case study. This one's actually from our backyard about what to do. We actually filed, I think, 4 lawsuits against the THC maker laced company. I don't know how to pronounce it, but Skittles, which you can see the similarities between Skittles and sort of the marketing that they're going after for THC laced candy. And I've also included a picture on the right that shows some of the things that our company and other confectionery companies are dealing with, where at home or small companies are ripping off our packaging. And you can't really see it in the picture very well, but in the back here, there's little hemp leaves and things, and that's the only indicator really that this is not a traditional Skittle. So these are CBD Skittles and medicated Skittles down here in different packaging, but again, they look very similar. And it's in our lawsuit, but there was an unfortunate case in Canada where a child ate from these and got very sick. And so companies like Mars really have to police their trademarks, not just from the big competitors ripping them off, but also these small little independent shops that are making the packaging or making the products or selling under our similar names, because obviously the worst thing that can happen is someone would get sick or confuse our goods with something that is not something that we've manufactured. Copyright. So these, of course, protect original works of authorship, including like literary, dramatic, musical, or artistic works. They're very inexpensive, less than $200 to file on, and they have quite a long term. I wanted to share a couple examples in the confectionery area that are copyrighted. So there's a very famous Pierre Mandarin painting called Composition. You can see this in the top right of the red, yellow, and blue, this piece of very famous art. And then a baker actually made a cake inspired version based on the art and was able to get a copyright on this beautiful confection down below that was inspired. And another example of even copyright is the characters. The M&M characters are protected by both trademark and copyright. So definitely something to consider if you have something similar in your client that you're representing, not real characters. And without further ado, I'm going to pass it on to colleague Margaux. There is no one in the world that loves candy more or plants. So she is our plants expert, and I never even knew this was a type of IP law until I started working for Mars and got to meet Margaux. So I'll hand it off to her.
Hi, so I'm here to talk about why we have an agricultural attorney and as here at a confectionery company. And that is heavily because candy ultimately is all raw ingredients, and most of the raw ingredients come from plants in one way or another. And the 3 primary plants that are the most important to Mars Wrigley are cocoa and peanut and mint, and also other nuts, but nothing is quite as important as peanut. And also I wanted to particularly call that out because that's where Mars' strongest ties to Georgia are, is we use Georgia peanuts in the majority of the Snickers and peanut M&Ms that are made in the United States. And so when we do peanut school and get people up to speed on all of the latest developments in peanut technology in non-pandemic times, we come to Georgia. So in different times, I will occasionally actually be in the area, but not anytime soon. So I generally, and yes, sugar is also, sugar and sugar cane and sugar beets are also key raw ingredients. But what's really, yes, they do. Sugar cane and sugar beets are still the primary sources of sugar in the US, in confectionery, everywhere in the world. And a bunch of the non-sugar, like not sugar, but sweetener alternatives are also ultimately plant derived. So one way or another, we're touching plants. I tend to focus more on the plants that contribute to flavor as opposed to the ones that are sweeteners, because that's where the most interesting IP is now. Long ago, there were a lot of developments in sugar, but most of the technology now today is in processing, so it shows up more in the traditional utility patent type space as opposed to being something where we're looking at the plant IP rights itself. But cocoa, peanut, and mint, it's a whole different story. And so for this, I thought we would go a little bit into some of the different ways that you can protect plants. I admittedly am presuming that most of the audience is not exceptionally familiar with plant IP rights. So if that's not true, I apologize for boring you, but hopefully this will be some new content for everyone. And one thing to keep in mind, also, if people could go on mute if they're not talking. I think we have a few different people with background noise. Thank you. So the plants get interesting because there's so many different ways to protect them from an intellectual property standpoint. They range from legal systems that were created entirely just to protect plants to using existing intellectual property systems simply to claim plants in different ways. Then there's also ways to use alternative forms of non-patent or patent similar intellectual property protection to also get some security around your investment in your research and development. It can be exceptionally difficult to protect and get value from your work in when you're working with plants, because you're talking about developments that happen on a massively different time scale. A new packaging development might take a year or a couple of years. A new plant development will take 20 years, 30 years. New cocoa, 30 plus years. And so the way that you think about strategy and the way that you think about creating your IP strategy means that you have to think on an entirely different timeline. And that particularly, so for mint, something that's quick growing is almost like a row crop, pretty, you can turn things pretty quickly. You can kind of use some more traditional forms of protection. When you start talking about something like a cocoa tree, you start having to get creative. This becomes important, and I want to do a little bit of cocoa biology just so you understand what exactly I mean here. When you plant a cocoa tree, you won't know if it's even going to produce any useful cocoa pods for a minimum of 3 years. You aren't even going to know if it's going to produce enough cocoa pods that you could harvest it to get cocoa beans to be able to make some cocoa and see if it tastes any good for between 5 and 7 years. And so only at that point can you start deciding, okay, did this thing that I breed actually, is it any good? Is it going to be helpful? And at that point, then only at that point can you decide what you're going to focus on, where you're going to go do trials, what exactly you're going to choose to protect. It can be 15 years before you really know what has value. So getting some return on that investment is really important, because you have to commit for so long before you even know if you have anything. And so that's why it's really important to think strategically about how you're handling your intellectual property for your germplasm, your plant material. So I realized, Carolyn, you're controlling the slides, so can you go to my next slide? So what most people who tend to be generally familiar with plants think of, they think about plant breeders' rights or plant variety protection. And those forms of protection are created frameworks that exist under what's called the International Union for the Protection of New Varieties of Plants, which is the UPOV. And most of the world is party to the UPOV, everywhere in green on this map. So if you're looking at a global portfolio, if you're looking at trying to protect a plant that grows all over the looking for protection under the UPOV can be a very smart thing to do. Where this kind of protection is only quasi-patent-like, and we'll probably come back to this, but I want to go through exactly, can't remember, sorry, I don't remember what my next slide was. Can you go to the next one and then go back? And sorry about this. I think my next, yeah. Carolyn, can you just go to the next slide? Yeah. Okay, perfect. This is the one I want. So we may need to go back to that map, but just keep that in mind for a minute. So what you get if you apply for protection under the UPOV, you get a set of rights called plant breeders' rights. The United States, though, had to be difficult because that's kind of how we always are when we join international treaties. So in the US, we have an equivalent protection of rights. We're still a party to the treaty, but we put a bunch of exemptions into our signing so that instead of plant breeders' rights, we have plant variety protection. And there are some differences in exactly what the scope is and what the exceptions are. And you don't really need to worry about it. If anyone has any specific questions, I'm happy to go through it. But in general, you can kind of conflate plant breeders' rights and plant variety rights for most purposes. And what you get with those are exclusive rights to produce the propagating material, so whatever you can use to make more plants, which most commonly is seeds. You can sell it, you can import the propagating material, you could stock it, you can license to somebody else. It's a 20-year term, like most patent terms, 25 for trees and woody vines, just to reflect the fact that, like I was talking about cocoa, takes a really long time to grow your tree to even know if it's worth having something to protect. And the tricky thing here is in the US, plant variety protection, and in most of the world, this only covers sexually reproducing plants, so things with seeds. The US recently extended plant variety protection to asexual plants too, but it was not a well thought through revision, because there's certain requirements, including deposit requirements, that are part of an application for plant variety protection. It's pretty easy to do a seed deposit. There is a national repository, you make your deposit, you move on with your life. If you're dealing with an asexually reproducing plant, that's a clone. And so you're going to have to cryogenically preserve it, or come up with some sort of equivalent method of preservation to make any sort of reasonable deposit. And so there's certain logistical hurdles that weren't really thought through. And in the United States, plant patents, which I'll touch on a little bit later, are available for asexually reproducing plants. So unless you really have a strong reason, there's not a lot of reason to use plant variety protection ever for anything other than sexually reproducing plants where you're dealing with seeds. What is interesting and important for Mars is mint and cocoa are clonal. You cannot, mint actually is a triploid and has some really interesting genetics, and basically for both mint and cocoa, you can't take the plant that you have and have it produce seeds or beans and get the same thing. You have to use alternate propagation methods. So that means that plant breeders' rights and plant variety protection are useful for in certain circumstances, but not necessarily where you have to do a seed deposit. So although in certain global schemes, it is still important where there is not a deposit requirement. So for the majority of the world, it doesn't require a specific deposit. You can still do it for clones, and that's something that is an important part of your strategy. If you could go to the next slide, Carolyn. Now the limitations on this protection primarily relates to the propagating material. So what that means is, let's say for cocoa, you can get this protection on the cocoa clone, this awesome new clone, or on the new mint clone that you have. But where it gets important for cocoa is you aren't actually, unlike with mint, you aren't eating the propagating material. You're eating the beans. You're eating something that's produced from the propagating material. So you could actually harvest cocoa beans and not infringe a plant breeder's rights protection on the cocoa plant. So you have to think about alternate methods if protecting the beans matters to you. There's an exemption for breeders to do further research that's much broader than the patent breeders exemption. And there's a farm safe seed exception, which is a lot more important for seed crops, where farmers can save their seeds year over year and you cannot stop them. So it's a much narrower scope of protection than a patent, but it's narrowly tailored to plants. So you don't have to worry about 112 issues and whatnot that are sometimes difficult to meet with botanical descriptions outside of a plant patent. So in order to get plant breeders' rights or plant variety protection, you need to have a breeder. You can't just go out in the wild and find something. It must not have been exploited, so offered for sale, sold, or only recently, usually within a year, kind of similar to a patent. Some countries have extended COVID exemptions on this that are up to 4 years, just because reflecting the difficulties with agriculture right now, and especially in some of the countries that are parties to the UPOV. And it needs to be distinct, uniform, and stable. This is the novelty and non-obviousness bit that for plant breeders' rights and plant variety protection. And so I have some pretty pictures to explain what that means. So if you go to the next slide, so distinct, it has to look different than all the other ones. So in cocoa, when we look at a new clone, we say, hey, is this different in a key characteristic than its parents? Does it produce more cocoa pods? Are the cocoa pods prettier, or does it have more flowers? For mint, is it resistant to verticillium wilt? Does it have a spearmint flavor? Does it have a peppermint flavor? What makes it different? That's your distinct. If you go to the next slide. So then once you have distinct, you have that characteristic needs to be reproducible. So now that you have it, you need to be able to show that it is uniform, that you can get that same spearmint flavor from the mint, that same peppermint flavor, that same cocoa yield every single time when you reproduce it, be it asexually or sexually, whatever makes sense. And then stable means that you can do it for more than one generation. Anybody who has ever done any kind of plant breeding on your own and just doing crosses in your garden, will know that your F1 and your subsequent generations may not be even remotely similar. And so you have to demonstrate a certain degree of stability in order to offer protection. So they didn't want to let people get some protection on a sport that was not reproducible. It wastes everyone's time and effort. So that's distinct, uniform, and stable for plant breeders' rights, plant variety rights. Now, the advantage to that is that kind of protection, as narrow as it is the most broadly available protection in the world. And that's really important because when you're looking at your plant strategy and you're looking at that long-term timescale, you really have to factor in climate change. Right now, cocoa only grows in a small band right around the equator, right about 18 degrees on either side. That we reasonably will expect that that's going to change over the next 10, 20, 30, 50 years. And 50 years is only 3 cocoa generations. So we need to start thinking, okay, well, we have a protection on an amazing clone in the countries where it currently grows. Do we need to get that protection in the southern United States? Do we need to get that protection in southern Europe? Do we need to get that protection in all of Australia? It really, you have to start thinking about where does agriculture occur now, but where might agriculture occur in the future for your crop in question. And that's where the single application with the UPOV can give you some of those options, even in the 20-year time frame that you're dealing with from a patent application. Even if it isn't quite as robust as what you could get in the US. Now, plant patents and utility patents are still extremely useful tools. You don't necessarily want to just rely on your UPOV protection because it does have a lot of exemptions. Whether a utility patent is going to be useful anywhere in the world is heavily going to depend on how patentable subject matter is defined and whether you can include plants or not. And that is regularly a subject for debate in every major patent jurisdiction ever. And I'm kind of just tabling that for your general life sciences 101 issues. But where plants are not specifically excluded, there's no reason that you can't file a utility patent on a useful plant. Generally, these are constructed as for example, like mint one, you'd have Mentha aerospigata that has a particularly unique peppermint flavor that makes it extremely useful in fighting off gingivitis in an oral care application. Or you would have a cocoa that has a particularly fine flavor that can be accomplished, that can allow you to make good tasting chocolate from places in the world where you wouldn't otherwise need to, or needs less fermentation time or something like that. So you can definitely use your standard utility patent techniques. And the nice thing is you can layer your protection. So you could get, as long as you are eligible, you can get your plant breeder's rights, you can get your plant patent, you can get your utility patent, as long as you can meet all of the requirements. So, and like many things, you can break your plant up into a lot of different components. This is my only interactive part. Looks like we're getting a little low on time, so I might just go through it. But there's 6 major claims that you can make on any plant, ranging from the actual plant genetics, where legally allowable, to looking at the plant as a whole, looking at the plant's function, looking at the plant's roots, breaking out the leaves, looking at the aesthetics, looking at, and so then you can, and so you can approach it in numerous different ways, like kind of like most other things that we like that packaging that was 500 different claims. You might not be able to get 500 out of a plant, but you can certainly get more than one. Go to the next slide. So plant patents are uniquely American. Get one claim to the plant as a whole, and you don't have to deal with the 112 problems that you run into with utility patents directed to plants. They are enablement and written description can be pretty tough to meet under normal patent standards if you're just getting a patent on the plant itself that without performing a specific function. That is explicitly met by statute by a full and complete botanical description in a plant patent. So it's much, much, much easier to get than any of the other kinds. And it's really a broad protection. You can get it for asexually reproduced plants only, and not tubers, because that's a relic of the Great Depression. When they created this system, they were worried about locking up the food supply. So no potatoes, no sunchokes. But unless it's that, you can, plant patent terms are exactly the same as utility patent. So you've got your, so 20 years. And so it's otherwise the exact same system. Like a design patent, the claim is special. It's instead of your usual claim language, you have a new and distinct variety of a cocoa tree, a mint plant, substantially as illustrated and described therein. In the old days, this was done by beautiful botanical illustrations, and old plant patents are stunning pieces of art. New ones are done by photos, usually taken on an iPhone. So, so 101 is an obstacle if you're doing it for utility patents, if you're doing standard crossbreeding. It is not an obstacle for plant patents because it's an exempted system. So basically 101 gets treated a bit differently in the plant patent context and does not apply at all when you're looking at rights under the UPOV. So if you're just doing standard sexual reproduction, you are not going to be able to do a utility patent that is on the plant itself. It would, if your plant has a particular special attribute, you would have to be able to distinguish the utility of that attribute as your hook to get around 101 and not the plant itself. Next slide. I think I'm gonna skip through this because I want to have time to get to our basically for trademarks. There's one big thing that you have to keep in mind. When you do your plant breeders' rights applications and your plant variety applications, the thing that people generally try to do is they try to put down their name for their plant, their varietal name, as their application description in their plant breeders' rights application. If you do that, you will not only you will lose your ability to get a trademark on it. There is a specific provision that was decided. If you go to the next slide, varietals and cultivar names cannot be held up with any sort of exclusivity in a patent variety of plant beyond the expiration of the patent. So if you look at well done plant breeders' rights applications, they all they're like some ridiculous string of letters and numbers usually is what the name of given to the varietal is. And then the actual varietal and cultivar name, they reserve for the trademark. And the apple industry in particular is very, very good at this. And they have a elaborate system of licensing for the use of the names for Honeycrisp and all of the children of Honeycrisp. As is the most famous example of that. This also occurs some in peanut. Next slide. So then, so I mentioned, there's also, because we're talking plants, there's different options that you can consider to create kind of a net around your plants. You can rely on Mother Nature and hybrid seeds. They have built-in IP protection because you cannot plant them and get the same thing again. And so that's what you see when you're dealing with a lot of the row crops that are grown in the US today. That's what you see. Potatoes, tomatoes, all the Solanaceae, are mostly sold via hybrid seeds, if not clones. And so you end up, you have to go back to the original source to get more. You can layer your plant breeders' rights and your patent rights. You could patent one parent and do a seed deposit, and then file a plant breeders' rights application on another parent in a country that may not require a seed deposit. And with that, which could prevent people from getting access to both of the parents needed to create the useful child that you're trying to protect. So there's lots of different ways that you can play with the intersection between biology and intellectual property to get some return on your investment for your development of your novel raw materials. So yeah, you see, I think there's a couple plant questions, and then we can go into the Yes, it absolutely does affect how we handle hiring people, how we handle non-competes. So what's interesting for cocoa is that a lot of the origins that cocoa grows in have employment laws that don't allow for non-competes. So in an ideal world, from an IP perspective, yes, we would absolutely want longer non-competes and we do longer non-competes for US breeders of particular skill in cocoa. But in the majority of the cocoa growing origins, it's not an option. So we heavily rely on robust monitoring of their confidentiality terms and a lot of training for everyone on reminders of their confidentiality obligations, and relying on breach of contract if we have reason to believe that there's been a leak on. One thing that is advantageous is often that simply due to the length of time, often the knowledge is actually held by people of multiple different generations who worked on a project, and it can be difficult to recreate the work without also having taken documents or material or actual germplasm with you. And so some of that, the simple logistics of having to have the appropriate field and space naturally help with protection there. I think those are all the plant ones. So then we can go to our overview. But yeah.
Thanks. And so I'm conscious of time. So real quick, as you're thinking about IP strategies for the clients and companies you work for, just reminding everyone, people ask me all the time, well, what is the IP strategy for your business? Well, my IP strategy is entirely tied to my business strategy. So it's really important that you understand the business strategy and that the IP falls in line with what that business strategy is, because it should not be the IP strategy that leads the business strategy. It's the other way around. So really can't emphasize that enough. Also want to make sure that you partner with the business to understand the technology so that you can advise your clients a little bit better. Consider all the different vehicles for protecting and maximizing your company's assets. That's a really important one that I think people oftentimes just look at patents, utility patents, but don't really think about the trade secrets aspect or other different ways you can protect a company's assets. Want to remind everyone to make sure your senior leaders understand the assets. That's been something that Margaux and I have spent a lot of time, is making sure people understand what assets we have, what our strategy is, and make sure that we get their buy-in on how that will help us with our business transformation. And lastly, you've got to train your associates, and not just legal associates, but your business associates and colleagues on IP issues so that they can issue spot these things and reach out at the appropriate time. We do have a quick little, Margaux, do you have to run or do you have a couple minutes?
I have time.
Okay.
I know that that we're supposed to be wrapping up.
I know, and it's always the worst when leaders go past their 1 hour because you don't get extra CLE credit time. But anyway, I thought we'd do a quick little group case study and see if you guys have learned anything today. So you've been hired by a new company to be their chief IP counsel. They want to produce the next generation of candy, sweets, and decorative decorations for the confectionery industry. So they've developed a 3D printed food components that create unique experiences. The technology can produce 3D models of sugar with intricate details. And this is all really happening, by the way. So they're about ready to launch their first commercial product. You can see a picture on the right that can be used as a cake topper. So what are some of the things you want to think about for your IP strategy? And we'll just spend a couple minutes on this. So if you want to, I don't know how to have people raise their hand, or they can type in the chat that they want to answer, and then I'll call on them. Let's do the chat. So if you think you have an idea of what you would do, go ahead and put in chat. Okay. All right. We've got copyright for the sculptural work. Nice. Any other ideas? Come on, you guys are patent attorneys. Design patent. Okay, good. What do you think you'd get the design patent on? Okay, the method of printing it. Awesome, right? The printers. Trademark. I think the name Newco may need some trademark marketing guidance. We may want to make something a little, yeah, get a nice catchy trademark. Awesome. That's right. So unfortunately, I should have done like something with a cocoa plant here to throw in plant, right? So my apologies, Margaux. I couldn't think of something that captured everything. But as you think about this, you can think about all the different ideas. But again, like, nobody got it on this one, but I'd love to encourage everyone to first ask, well, what is your business strategy? Because maybe my business strategy is to sell the printers, right? So want people to sort of think about that, or maybe I'm an ingredient company and want to sell the ingredients to make it with, you know, you got to think first about the business strategy before you decide what your IP strategy is going to be. But anyway, that was just a fun little thing to bring it all home. Does anyone have any questions for Margaux or I? Any questions for Margaux or me? Excuse me. I don't know what's the end of the day. The grammar's just gone right out the window. All right. Well, hearing none, I hope everyone's gone to their kitchens to grab some Mars candy. Oh, there was a question. Do you have university partnerships for research? Absolutely. We are one of the, we do a ton of sponsored research, both with academic partners, but also with startups and nonprofits. And so Margaux.
University of Georgia and peanut work.
Yes, I also, I do some work with North Carolina State University on paper mills and paper things for our sustainable packaging efforts. But yes, we are always working with academia to get some really cool innovations from them. Well, thank you again so much for inviting us. I think you should have our contact information if you ever want to reach out and have any questions, but it's been an absolute pleasure to talk with you today, and hopefully you learned something. If nothing else, I at least learned way more about what Margaux does. I just defer all planned questions to her anyway. But we hope you guys enjoy the rest of your evening networking, and I guess we'll be in touch.
Thank you so